The other day I asked who could sign a contract of sale, right? That was the question. And I gave all of the persons and entities that could be the buyer. I don't actually know if I said the seller also has to sign. Right? Both parties have to be signatories to the contract. So real property is sold by contract. That's in New York State and in all of the states. A verbal agreement to sell is not binding. It has to be in writing. It could be a back of the napkin deal. It could be the pre-printed form contract that people use. It could be an attorney drawn up contract. Well, in New York, it should be an attorney drawn contract. What I meant is it could be complicated or simple. It could be 4 pages. It could be 22 pages. You have to sell property through a contract of sale. There's the seller. The seller could be any one of a number of entities, a corporation, a real person, a trust. The buyer can be the same. There's always terms to the contract of sale that are negotiated points. You need the names of the persons, and I got that. It has to be sold by the owner. A third party can't sell a property. You need the price. Seller and buyer have to agree on certain contingencies within the contract. Price is one of them. The down payment and how much mortgage can be borrowed. So if you're buying a property for $1 million, if the buyer had to borrow $990,000, that's less of a secure deal. If the borrower borrower, right, there's a slash there, only borrowed $200,000 and they put down $800,000 from their bank account and only borrowed $200,000, well, that would be a very secure deal. So it's a negotiated point. How much is the seller willing to permit the buyer to borrow? In residential contracts, a conventional mortgage is borrowing 80% of the sales price. In small commercial transactions, a typical transaction would be 30% down, 70% of the price of the property as a mortgage. I'll keep going. I'll tell you some more, but it won't be until tomorrow. And in the meantime, take a look at the website, frankbrunolaw.com.